Hello, everyone. Welcome to LexTalk World's talk show presented by ClickAway Creators. Today, we have Mr. Dikshat Mehra with us. He's a principal associate at Rajani Associates, which is a full-service law firm based in Mumbai, here in India. Gentleman possesses an experience of more than 9 years, and his practice areas majorly are litigation, commercial law, arbitration, and insolvency matters as well. There are so many things that he and his firm covers, so we'll discuss that on the go in the session. But before that, without further ado, let me introduce you to the man himself. Hello, Mr. Mehra. How are you doing?
I'm good, Sagar. Thank you. Good morning to you.
Very good morning, and thank you very much for joining us. I hope we'll be having a great session today for our viewers, and we'll try them. We'll hope that they can understand more about legal space, as it's all what we are for. All right. So, Mr. Vera, I tried my level best to cover things about you. It was a very small bio that I had with me, but it would be great if I can understand more about you in your own words. So, if it would be wonderful if you can, brief us about your journey as a legal professional so far, and about your expertise as well.
So Sagar, to start back 9 years back, it's quite funny because I always wanted something where I would join a career would make a difference. So I had a family background of a business which was into textiles. So I started initially started working with my family business, and slowly I started realizing possibly this could be the one where I would actually lead up to. And so in pursuit of that, I started thinking that let's get into the MBA, the usual master's business administration, what we will normally think when you come out of your 11th and your 12th of grade, you'll wonder you'll want to do that. Now, of course, I started exploring options in that way. An incident which of course took place at that time, my law did of course cross my mind at that time. But when they say when the time is not right and it will not just click. So the incident goes like this, that I actually applied for a law school in Pune, which is in India. So I actually applied for that, and I realized that due to some technical glitch, my application was not accepted. And I wondered, I said, I actually made all the effort, and I thought now I was between MBA and this, and where do I go? And I realized, okay, possibly this is not something which is right now at the moment. And I went with the flow, and I realized then, okay, I said, why not do an BMS? So I've done my management from the Mumbai University also before getting into law. So whilst I was doing my management sometime in the second year, I thought that possibly it's again a time just to rethink and possibly again do, at least make an attempt. I mean, what if I just fail again? But I said, let's make an attempt. And I'm actually thankful to my parents and my really best friend, Mr. Rishabh Chopani, who actually just pursued and who said that just go ahead and do it. I mean, as I said, since I was already going to do my business, he said this is be an aid to your business. But I mean, really, with Almighty's grace, I'm actually pursuing it as a career now for the last 9.5 years. So that's been the journey. I'm a first generation lawyer, so I mean, right up to my family tree, I don't think there is anybody who's actually even stepped in, if I may say so, in the law field. So that was a little. Of course, it was challenging. I mean, initially, but I'm again very grateful, as I said, to my parents and of course to my almighty and my seniors. I would also say that initially, at my partners, the current and the past partners at Rajani Associates. So I think that entire journey, I think I was fortunate. Let me put it very simply. I was fortunate that initially of my career that I got in a lot of to learn in various facets of law. So it was just thrown up, and I think with this just throwing up to me, I think possibly today I can really proudly say that yes, I have learned this initially at my stage. So yeah, that's how it has been journey. And as far as expertise, I think again a little background. I did a little bit of corporate, to be honest, when I started off. But then I soon just realized that maybe corporate is not what I'm looking at. So I really switched to the litigation, and I wondered that okay, litigation is something which I'm interested in, and of course the arbitrations. So I switched on, and I said that this is where I want to do it. And as I said, got to learn initially at various facets. So I think that's about in terms of, so as it was commercial litigation, it's arbitration, insolvency. I also do a little bit of IPR matters, purely trademark and copyright that we also, and of course the white collar clients. So
That's
about.
that's a quite experiential brief that I have ever heard. I mean, background from generally lawyers generally, they have a tree of lawyers. I mean, they generally do it that way. But coming from business background then towards legal, I mean, it's it's really horrendous. And kudos to you for coming out and glowing up in your respective genre specifically. Okay, talking about lawyers, if I'm talking to a lawyer, it's really of no use that I don't ask you about the case. So it really excites me, and I hope to our viewers as well. So that's the question that I always ask. It would be great if you can tell us about your most memorable case, and of course, what are your key takeaways from there?
Uh, uh, it's a question, Sagar, honestly, which is, you ask any lawyer in terms of his experience. So you may ask one of these, the great senior counsels we all have in our country, and you ask them, pick up one where, you actually argued the best, or you've kind of drafted something in the best. But to be honest, I mean, there have been various phases, but what can immediately just possibly come to my mind are 2-3 cases. One was, of course, a major case where we had the corporate hijacking. Now, why do we call it as a corporate hijacking? Because the court actually held that in our favor. So it was there were these two companies, and overnight the directors of the company were changed, and there were the records of the statutory records of the ROC, where usually the companies file it. They were changed overnight, and my signatories, all of the company were removed, and there were people, the so-called scamsters or fraudsters, actually got inside the company. And I had a 2,000 crore land in that particular company. So we of course, it was really in great terms of strategizing that where do we go? We go to an X forum or we go to a Y forum. But of course, with all the legal minds, and we sat and I think within the next 48, 72 hours, we just filed it before the High Court. And we of course took the best of our counsels, and we actually got in we got in our relief, where we actually realized the court itself recognized, and that's why exactly I first used the word corporate hijacking. And because the example was given, if this has happened to your a company which is having, what if it happens to a company which is or an exposure, let's say a company like a Reliance or somebody, like, it can happen with anybody. So I think there were a lot of safeguards which actually came in. A lot to learn in terms of from various, even from the ministry perspective, because we had to get them also. I mean, the court wanted to get them also because they had to actually, ensure that this doesn't happen with any other company. So that was one of the very great, remarkable, in terms of both, I think in terms of, I would say, learning about the statutory thing, and also equally with the law. And I think possibly the second one could be, I mean, of course, I've done 2 arbitrations, which, arbitration being confidential, would not speak much on that. But I think in terms of exposure in an LCI and a CIAC arbitration, which, again, fortunate enough that I got it very early in my career, I think that was, again, a very good learning experience in terms of it. And I think possibly lastly could be an enforcement of a judgment, which is actually still on, to be honest. I started my career, and it is still on. And it is quite interesting, because I think that is the entire ethos of the entire procedure code of enforcing a foreign judgment within your own country. And so I think that really had a lot of takeaways to be done. And in terms of research, I would say also research and strategizing. I think at every given point of time, we had to strategize a lot.
That's right. That's right. A general question, if I may ask. What's the approach of a lawyer towards such a brutal cases? I mean, when I hear like a layman like me, if I hear a term called 2,000 crores, like I lose my, you know what I mean. But how a lawyer really sees, and what is the approach that you guys have?
So if you're telling in terms of quantum and this, so again, I mean, if you're strictly speaking in terms of the facts of that case, I mean, we were shocked, first and foremost, when the clients turned up and they came to us, and we were wondering that how does this even happen? I mean, There's got to be some kind of a glitch. So to be very honest, yes, we were taken aback. But at the same time, when we deal with such, and to be honest to you, I think Sagar, that has become the normal routine, I think, in the last 5-6 years, where one may see that if you're talking about volume-wise, when it's a 1,000 crore, it's a 2,000 crore, I think it has become a really a scenario in the sense that, I mean, I would never say that a dispute which is of 2,000 crore or even a 200 crore, because I, personally, and how we look at it even from the firm perspective, that we got to learn from every facet. So it's a challenging for a lawyer, and I always tell that even to my possibly the interns and juniors with me, that it's never about the exposure, or it's never about just that, oh, it's a 2,000 or it's a 4,000. Yes, it's good. It's good in those being in those clubs, if I may say. But at the same time, I have also done a dispute and an arbitration, which I think was 3 or 4 crores. But that arbitration actually went up to the Supreme Court, and we settled a proposition of law and an arbitration, and it still stands. So I think the quantum-wise, let me put it, you have more mess at the 2,000 crore, whereas in a 20 or a 5 crore, you possibly will actually pick up a law point, which is actually interests the lawyers also. So I think we look at it with the same this thing. It's not that, oh, you are an ex and you've come by way of a normal suit, and which is only 50 lakhs recovery, and we will not. But possibly the 50 lakhs will have much more experience and exposure. So
that's, yeah, of course, this better. All right, we'll also talk about something about law tech here, because this is something that is booming, and especially in India, we are still lacking about it. But before we do it, let's deep down something more about your practice as well. So if I may ask, how do you look at commercial litigation, IBC and arbitration 2021, and how it's going to change 5 years down the line?
Again, Saga, I think here, let me break it down to pre and post, like let's say on 2020 and 2021, and then 5 years down. I think if you see the last 4-5 years, or 6 years possibly, I think a lot of things have been changing at the commercial litigation. So it's a very simple thing that my seeds are sown of the country, where people are actually put in the efforts, but now it's only a matter of growing. We know we put in a plant, and it takes in some time to grow. So if you ask from an industry perspective, I think things are actually changing. And when I say changing, I think because if I may just put it, that you had the commercial laws which actually came, that is the Commercial Act 2015. You had the arbitration, which was 2-3 times were actually amended so as to keep up pace with your international. Because to be frank, we always look at it to say, oh, let the India become a hub of arbitration. I'm sure you possibly would be also hearing this. It's a general perspective that we also hear, that we say, oh, India is the seat of arbitration, let India make the hub. But I think this is a step towards it. I'm not saying that we have achieved. I think so that comes to the second part of what actually we to achieve. I think technology, in my view, will just play a lot of role in terms of the arbitration. And frankly and personally, looking at it from my perspective, I would possibly look at it where the appointment procedure takes place, in an arbitration. For me to change that particular thing in the in the facet of an arbitration, I think that's one thing where I will possibly, of course, there have been amendments to that effect, that an arbitrator should be appointed by the institutional, but unfortunately that amendment has not been come into force now. So I'm expecting and hoping that sooner or later that things will be streamlined, and it will be. And as I said, technology, I think it's needless to say that because of the pandemic, maybe sometimes people put it as the pandemic was a boon for a technology perspective. Otherwise, where it been a situation that somebody would be using such apps, yes, we were using it, but when we use it in more like an international arbitration, but to use it in your daily routine, I think it has become, and why not? Because I can today, sitting here, I also appear before the Delhi High Court, I am before the Bombay High Court, I'm before a tribunal, and I'm before even possibly the Gujarat High Court. So
that's right.
I cover various other facets when I am dealing with it. So I think that's how I look at it. And yes, More changes are to be welcome, because of, we all are aware that how India is looked at from a slow litigation. When it comes to litigation, and people will be like, I don't think, I mean, unlike you see in the West and the US, people say, oh, trial. I don't think we should go to trial. I mean, that's because the cost is really huge. But here in India, say, yes, you want to get into trial, but then you're looking at 15 years. As I said, I am still doing a matter, which is almost 10, 11 years. So that speaks it all, I think. But it would change in the coming times with the commercial laws and with the insolvency also taking, yes, there are hurdles, but I always believe that any enactment or any new situation would always have, we'll always learn with it and we'll always improve. Like, again, giving the example of pandemic, nobody knew the world was a pandemic of a COVID, but we are living up to it, and now, taking it as a, I would not say as a part of it, but actually improving ourselves in terms of this entire aspect. So yeah, so I think things will change in the next 5 years, and from the commercial aspect too.
Oh, hopefully. In this conversation, there's one more thing that came up to me. For a layman like me, or for for our viewers as well, if they're looking at it, why does it take a case to reach a span of 10 years and 15 years? How does it happen? I mean, if there's a serious case that just happened, I mean, we have so many examples in our country. Why does it take 10 years or 15 years to come up with a decision, or to come up with a verdict on that?
I think, I think this has multiple facets, so because it's a process. I always believe that your filing of your particular, so let's start, like, you realize that a client comes to you and he says that, yes, these are your facts, and you need to file possibly a suit for whatever. I'm not getting into the specifics, but let's say that is from your strategizing and to drafting and then filing. You also realize that, yes, the client would be needing some urgent relief in that particular, because there is a situation that the other party is going to dispose of his assets. And in that sense, he will have only a paper decree with him. So, of course, at that time, one goes to court and gets urgent reliefs. But what happens in the entire process is that the main proceeding itself would actually be stalled because of that interim, because the party who's got the interim would possibly be sitting it tight, that I know that you can't dispose of your assets. So it's vice versa for the party whose the order is against. He will possibly land up in court and saying that, okay, let me get this set aside, or let me at least get it modified, because I can't do my running day-to-day business or the affairs of the company. Now, why does it take long? I think it is purely to do in terms of the appointment of our judges and infrastructure. I always believe that these are some things which are coming in, because I don't think it's all over, and you possibly, one can research this in terms of pendency of our cases. So it happens that we are unable to, settle our previous cases, and the backlog is just been increasing and mounting. And I think it's because of, and let me not take away from the witnesses who actually come in, I mean, let's say you have a suit and you have 4 or 5 different witnesses. Till they actually read their witness stage, they are possibly 50 or 55 years and 60 years. So it becomes difficult for them to even come there and, kind of recollect their entire scenario or what exactly has happened. So I think it's a multifaceted in terms of, if one may has to put it in terms of appointment of judges, infrastructure. I think all this needs to be a little more streamlined. And I think more encouragement for, and the judges as now it's something which is just recently where the Supreme Court actually says that, I mean, in terms of your tribunals, I think the same situation arises from your tribunals. You have matters which are just being pending, and we don't even get that one relief for an 8-10 months, though the statute says that it has to be disposed of. But then, unfortunately, because of this situation where there is a backlog, and you don't have your members, that becomes a little, and same for the High Court. I think the same happens there, that you just cannot, a matter would not actually reach. So let's say a 2010 suit, which I'm talking about myself personally also, a 2010 suit will not take precedence because it will come with its time. So a 2008 suit is given because it is, of course, pending much prior to 2010. So till I reach my 2010, it will be 2022 till I actually get my opportunity. I think same thing happens with your writ petitions and etc. So I think technology, if I may put it in terms of appointment of the judges, where we actually need, and a quick disposal, and that's exactly when I made the reference of a commercial court, because you have your process which is streamlined, and it's not that one has not done suits in the less span of time. Of course, mediation is always welcome. I always look at it. Even mediation is something which our country actually should focus more on being. Mediation is something which is not given a statutory backing at times. Be your commercial suit. So I think that itself also needs a little relook in terms of where people can actually mediate and sit and close. And family disputes are the greatest example, But end of the day, yeah, I think this will take its own time to come up. And I think the appointment and infrastructure, if you ask me the two immediate things which are required, yes, that is something which comes in. And possibly we'll have some change.
I am, of course, looking towards the changes that we all are expecting. Talking about change, if there is any element you would like to change in Indian arbitration regime, and if yes, what would it be as part of improving the process?
So again, what immediately comes to mind is appointment of the arbitrators. What happens is, just to give a layman's perspective. So let's say a party A and a party B, where there is an arbitration agreement between the parties, and the A and B can't decide on a particular arbitrator. So they have to actually file your appropriate application before the High Court or the Supreme Court, as the case may be. Now, what happens in this scenario is that your application is actually pending because there is the backlog of pendency. What happens is that your particular application is not being taken up, as expeditiously as it could be. Now, I may say Delhi High Court in this cases are quite proactive in the sense because they have a designated bench who actually deals with these matters. So what happens is that the pendency of that particular application gets disposed of, and that's an amendment which has taken place in the Arbitration Act, where the legislature in that sense sort of more prudent that you have arbitration institutions who can actually appoint, and you do not have to come to court. And what's the benefit? I think it's a no-brainer that the arbitration institution will be much quicker because they can dispose of, and they've got the entire expertise in terms of their work, and they have dealt with such. So your process becomes much more expedited, I would feel, unless if you have to go to court, because if you're assuming you're going to court, you have easily a year where your application is disposed of. After that, your arbitration actually commences. So then what is the difference between a normal suit and in terms of an arbitration? So I think that is something which hopefully the amendment comes into in effect sooner or later. And I think the other part, if I may look at it, it is more to do with the rules of evidence, I feel, in arbitration, because arbitration, and again to explain in a layman's, it is something where you're not strictly bound by the rules of your normal court procedures. Because it's an arbitration, it's an informal and sitting, in a particular aspect. So it is more to do with an informal procedure in that sense. So rules of evidence, I think, something really requires, and this is honestly where I have personally managed international arbitration, and I realized that is something which should also be embedded in our domestic arbitration regime. Yes, there have been a few forums like the IIFL, the Indian Arbitration Forum. It is a very good forum in terms of where they've actually got up these rules, and it's more of parties actually accepting and lawyers like us, actually accepting those rules in your domestic arbitrations, which I think will go a way for changing the landscape, if I may call, of the arbitration regime in India. So I think that is, and technology, as I said, that falls out for all over. I think that is something which will just be there, and it will be there for now, times to come.
I guess the change also starts from the grassroots. We have institutes like IIAM, Indian Institute of Arbitration Mediation. So I guess the change starts from there as well. Guess new lawyers that are coming along, if they require change, they of course will ask for it, and then of course that's how the revolution begins. We ask for it, and then it has to happen. Talking about something more, then we'll hop up to the law. The law tech part. what are the important skills of for any lawyer handling commercial litigation matters specifically?
Uh, I think it's again very difficult to streamline particular, because your skill is developed over the years, as
Mm-hmm.
I believe. And but the only thing how I believe in terms of skill is one is updating yourself. I mean, something which is on a regular update. So let it be even a judgment of, let's say, the Calcutta High Court, or let's say even of the Jharkhand High Court. Uh, every facet of reading, I would say, for me, it's always been that just read, read, and read.
Mm-hmm.
How much ever one would read, of course, I call law as a situation is like an ocean. One cannot know every facet of the law. There is
Mm-hmm.
something which will, of course, be held. And this was actually my old partner and my ex partner who I used to work under used to always actually wonder and say that there's got to be something that you will find which will go in your favor, or possibly you will find something, because it's an ocean. Here we are only looking, but how do you cover that ocean? Is just updating yourself in terms of just reading and reading and reading. I think you just keep on telling that you've got to read this, you've got to read some other, your different facets, and you learn from that facet. So let's say if you look at it from a matter which comes to you, you need to first analyze and strategize what exactly has the client come to you. I mean, what is his entire aim and objective? It could be starting from recovery, it could be anything. But how do you guide him to that process? In terms of giving him new scenarios where you could possibly file an A application, you could possibly go 5, you could go criminal, you could do multifaceted. So
Mm-hmm.
any client would just look at it from a skill perspective that, oh, okay, he's the one who's possibly read on this new aspect. So let's say yesterday there is something really huge comes up from a particular commercial aspect, from let's say your guarantors or your promoters of the company. I think there will be a whole lot of questions the next day from the various aspects, because people will just read a particular news article and they'll wonder and they'll come and immediately pick up the call to the
That's right.
lawyer that, have you read this? And at that given point of time, I think you can't just say that no, and I missed it, or possibly anything. I mean, of course, it's really not human at times to know everything, as I said.
Mm-hmm.
But at least if you get a little gist of that particular, you can really advise them, because that's how clients want. They want quick solutions in terms of your commercial, So I would believe, and of course, time management. I also believe that that's a skill that one has to do a little bit of multitasking in terms of, you have to actually manage your particular thing at a particular time, because if you're taking an X time on an X document, that is possibly not what the client is looking at. I mean, of course, you would know that more bigger the document, you would need more time. So I think that is something which is there. And your communication skills, I think that's again a no, this thing from a lawyer's, this thing is that something, because if you do not, and proofreading also at that
Yeah,
matter, because there have been situations at certain documents that one would actually miss out to, possibly put in your particular punctuation mark, and that will actually change the scenario. Uh, uh,
that's right.
to be frank,
That's
I
right.
think in the litigation, when we go and from the court's perspective, sometimes the judges are not looking at that, because they are more on focused on the matter and your relief, what you are there. But as for the corporate, I think there have been situations where this actually will term, and even in the court proceeding, I'm not saying that it is not that effective, but it can actually change your scenario, from what you are actually reading and what the other side is
No,
reading.
that's
So
right. That's right. It's like
yeah,
reading. I have not murdered 28 people. So if you keep on pressurizing different words on the same sentence, the meaning would be entirely different.
entirely. So it's very important to understand, as I said, first analyzing, of exactly what is the client's needs, and analyzing your facts. I always believe in first analyzing the facts and then applying your facts to the law. I mean, at times it happens vice versa, that you say, oh, there is a law, but let's apply it to the fact. But then possibly you go back to your brief and you saying that I don't think it will fall here. It's a little different scenario. So that is something which is very important. So as I said, read and keep updating yourself is something which I strongly believe in.
Oh, that's very beautifully put. That's very beautifully put. Now, before we end this session, let's talk about law tech. So AI, artificial intelligence, everyone have heard of it. Irrespective of which genre you're working with, but AI is there now. Um, what are we looking at, in terms of implementing of artificial intelligence into legal space or law field per se?
I think the first thing is that to remove certain fear of people that, lawyers will get replaced in the next 10 years. Possibly that's on a lighter thing, but I don't think that's really going to happen. I believe that technology always and your artificial intelligence will always complement you at your work. We always know that there are search engines already today existing in terms of finding your possibly your judgments and case laws, and actually putting everything in at your particular, just on your fingertip on your laptop, or you realize that you don't have to actually run through papers. I mean, if you ask any of the seniors who possibly did law 20, 30, 40 years back, they'll possibly this is the first thing they'll tell you, that it has become very easy for you to possibly find anything online. But in those days it was actually difficult, because that was something, reading and actually finding your case laws from those plethora of books which are there in front of you, and it is very difficult. So I think, yes, things have made it easier, and it is very advantage, but it's not here to replace. I think complement this thing, especially from a corporate perspective. Again, it will actually be able to highlight your certain issues in that document, which again a human possibly can miss out for whatever reason. But again, nothing I believe is what a human can actually analyze and put it. Yes, but the way things are, we can't say that how in AI it's going to change in the next coming years. 5-10 years, I think it is going to be a complete boon, if I say, which is there from the law perspective. And I think it's really going to complement. But how I also look at it, I mean, a simple example is being from a dispute perspective, like let's say a family. I always believe that sometimes emotions is something where a lawyer and a client would possibly discuss with you, and he would be sitting there and he would be giving you an XY scenario with his family. So possibly here your AI takes a little backseat, because he's not emotional. He's not going to possibly look at it from saying that, oh, okay, your XYZ has done with a ABC, and this is what exactly transpired. But that touch of a human element, I think there it kicks in, and then there AI takes a little a backseat. So I think it's balancing. It's really a balancing act for both, if I may say so. But yes, it's here to stay, and it is actually beneficial for a lot of, and even from the client's perspective. I mean, our turnaround drafts could be as as quick and what we earlier could have done. It's obviously increased, and it will increase going further. So yeah, I think that's it from the AI's perspective. It is here to grow.
No, that's right. That's right. I mean, if we even see it from a very, very, very niche perspective, I mean, if you are filing a case, or if you're doing some proofreading, if you have some application or something that can, rectify your punctuations or rectify your language in terms of legal fraternity, then that is also implementation of technology into the legal space. And these small things really, brings a revolution towards the industry.
Of course.
That's very beautifully put. And before I end this session, I always love to mention this. In one of the Indian movie, it was mentioned that legal industry, it's not the business of justice, it's a business of law. So as soon as you understand this, you'll understand that no lawyer can be replaced with any technology, because it's all about laws, and no AI even can understand about how law really works, because it differs for every case that you see in your career. And I hope Mr. Mehra will agree with that. If I have an agreement on that, then we'll put a stop for this session as of now. And of course, let's thank Mr. Mehra. So thank you, Mr. Mehra, for joining us for this session and sharing such great insights with us about your profile, and in terms of legal industry as well in a generic term. And not to mention, we look forward to having a chat with you again in the future on some other trending topics in the international legal industry. Is there anything that you want to say before we greet our viewers as well?
No, thank you, Sagar.
All right, thank you, Mr. Mehra. And now for our viewers, if you like this chat with Mr. Mehra, please like and share this video, and also click on that red button and subscribe to ClickAway Creators YouTube channel to appreciate what we do. And you have more coming in from legal industry leaders like Mr. Dikshat Mehra. This was Sagar for LexTalk World, signing off. Thank you very much.